So, hey guys, welcome back to the channel. I'm Fancy.
I'm Brandy.
And this is Murder by Design. And oh my gosh, guys, we have such a great show planned for you today. As always, we have one of our guest hosts with us, our guests experts that come on and talk with us and donate their time to us, which we just thank them all so very much. And we have one of our favorite guys on here, Kirk Nurmi. I gotta tell you, when I first met him, I didn't think I was gonna like him, but I absolutely adore him. I think he's such a great guy. And our audience really likes him. So welcome back, Kirk. Thank you for joining us today.
Fancy, Brandy, it's great to be back with you guys. It's been too long, so it's nice to sit down and talk a little true crime with both you ladies.
Thank you
so much.
It has been. It's been a long time. We have been swamped. Let me tell you, we've been swamped. And we're working on an actual documentary right now on John Bonet with Paula Woodward, and so that's taking a lot of our time. And we've been adding a lot of new shows onto the channel. So I mean, it's been crazy busy. But
it sounds like it's all good things. So that's
absolutely absolutely. The company
we could use about 6 more hours in the day.
Yes.
Couldn't we all, right?
We could just cut out sleeping altogether. I mean, I only get about 2 or 3 hours as it is right now. But
what the hell's with that? Why do we gotta sleep? I mean,
highly overrated. Going to the bathroom and sleeping, highly overrated. So today we're gonna talk about one of the craziest cases going on right now. I think Lori Vallow and Letecia Stauch are vying for which one can be the craziest. I think that's what's going on right now.
That should have kicked us off of what 2020 was bringing.
Oh God, yes.
I'm just saying.
Yes, definitely. Because there was way too many crazy things that happened in 2020 in the legal justice system. It was awful. But Kirk, now you've been following this case, the Letecia Stauch case. So why don't you tell us a little bit about what you think about the case so far and what you've kind of been talking about with the other people that you talk with us about?
Sure. I mean, the case first came on my radar back. I was on Crime Stories with Nancy Grace months ago now, right? And just kind of talking about this. And I remember reading through all these articles and like, you got to be kidding me, right? And then, the blood-soaked room, all this stuff, and then the potential, like what happened to the body? How did she get the body to? I know a little bit about the case for those who don't. I guess they're going to have to look it up before. But the body in Florida, and she drove it with it, et cetera, right? So it was some really crazy stuff. And so since then I've kind of had my eye on it, but my eye's been a little bit off with some of the other commentating I'm doing on different cases. But then, of course, when she represented herself, everybody, the minute a crazy defendant who is female does anything crazy, I guess I'm the first person a lot of people think of, because my phone blows up with requests like Fancy sent me saying, "Hey, can you come on?" So here I am, and I've had a chance a couple nights ago to be on Web Sleuths with Trisha Griffin, who's phenomenal, and Scrappy Joe. I got to give her dog a shout out as well.
I love Scrappy Joe. He's so sweet.
I'm a dog lover, so
I
got to give Scrappy Joe a shout out. And my fee for being on her show is now an extra treat for Scrappy Joe. So that's my appearance. Awesome. That's my appearance.
That's your appearance fee. That's your crazy appearance fee. Yeah.
Give Scrappy Joe an extra tidbit there.
That's so
cute. So I started looking at what she was doing. Her. She had this, I guess they called it a confrontation hearing that was behind closed doors. And then we had the choice of her to go represent herself. And just looking at that, because I've been in that situation. And to kind of look at it and see, I think I tweeted out or put something on social media that, I feel more sorry for her lawyers now more than ever. I always have, but the spectacle of this case and Ms. Stauch,
right,
is going
Right.
to be raised by her choice, which might be
Now-
part of her motivation. But
I think it is. Now, and I do have questions about that later on
Sure.
too. But I think about the saying of like any person who represents, and I don't know if I'm saying it right, but it's like something about if anybody represents themselves, they have a fool for a lawyer. Like I've heard that saying before.
A fool for a client.
A fool for a client. Yeah, there you go. That's a fool for a client, right? So, I mean, I just think, especially in a case like this, like, what does she think she's doing? It just blows my mind away. And the thing is that, like, Brandy and I talked about it I think it was just a month ago that
in
we were
January, she was
in a
they came back
competency
and just
hearing.
said that she was sane to go through trial. So a month later, she's filing the Aguila hearing to represent herself, and I'm just like, I am so confused by that. How that's even seen as okay in any realm.
Well, sure. Let's back up a bit. So competency to stand trial is pretty minimal. I mean, it's really an orientation thing. I mean, I think in my 15 years, I only had one case that I could think of where the person was actually declared guilty except insane. And he had a long history of state hospital stays, et cetera, et cetera.
The insanity defense is very hard to prove, right?
Right. But not even insanity defense, but competency to stand trial, assist your attorneys, that sort of thing, right? And the insanity defense, that opens up a whole new can of worms we probably don't want to open today. But when we talk about the self-representation, to Brandy's question, is that if you're deemed competent to stand trial, that means you're competent to represent yourself. Because the Sixth Amendment, it's the same kind of animal, if you will, because the Sixth Amendment guarantees your right to a fair trial, jury of your peers, all the things it guarantees, right? And the assistance of counsel. Well, and there's other amendments that express your right to get a fair trial, and they all speak to it in different ways. But the point is, if you're considered competent to assist your attorneys, and that's really the competency standard, if you can understand what's going on, if you're competent to assist your attorneys. Well, if you're considered competent to understand what's going on in the courtroom and understand and communicate with your attorneys, then de facto, you have that Sixth Amendment right to defend yourself. You always do. Once you're considered competent, there's no extra hurdle. Now, there was a few things that seemed a little different at how they do it in Colorado than the way it's done in Arizona, and some of the precedent there regarding whether you can jump back and forth and that sort of thing in terms of I want my lawyer, I don't want my lawyer, that sort of thing. But really, once that is a de facto right that somebody has, at least on the first time.
Now, is it something that can come up later where she can use that to be like ineffective counsel? Or that she didn't get a mistrial or something like that? Is that something that can come back to to the courts later?
Well, possible. It doesn't mean it wouldn't be urged, but I don't think it'll fly very far. And here's why. What happens is, and we saw the judge do this the other day when at this hearing, goes through the litany of the reasons why she is in better hands if she uses the counsel of her lawyers instead of herself, right? So you go through this litany, you're going to be held to these standards, et cetera, et cetera. I think he even made a comment about she could be removed from the courtroom with annex, things of that nature, right? So what that advisement does is it grounds any arguments of ineffective assistance of counsel, because you were advised that you don't know what you're doing. You want to do it anyway, and somebody says, yeah, I do. That really just grounds the whole idea of ineffective assistance of counsel. Because think about it, if that was the game, as it were, everybody would represent themselves, take a shot, say I'm incompetent, and come back with an attorney and see what happens that time.
And see what happens on the set. Right. So you get two trials. Right. Yeah, exactly.
I mean, I do think that this judge covered basis in everything I've read that they released that was said on clearing up with her what she had access to, what she didn't have access to, that she did not know the law. You know, I do think he covered all of that with her. And that's what I was wondering, if that was why he went and he kind of went around that question a bunch in different ways of explaining it to make sure she truly understood she was shooting herself in the foot here.
Well, it's not just, it is a matter of understanding, but it's also a matter of everything in the law is a long game. And so when a court of appeals reviews her, say, petition for ineffective assistance of counsel, or the court does, or what have you, and they sit there and go, you're complaining about X, Y, and Z about the effectiveness of your counsel, but you were warned about these things,
Right.
and you proceeded anyway. Therefore, the argument is non-existent. It's mute. So, yeah, I mean, ultimately, that's why it's done. It's done, yes, to advise the client, because really a judge doesn't want somebody representing themselves in a courtroom, because trial takes longer. There's all kinds of crap involved, crap that could go wrong. But, and that's a legal term, crap, by the way.
I agree. It works.
But yeah, so a judge doesn't want that to happen, so he or she's going to discourage that. But they're also setting the foundation for, you know what you're getting into, so you can't whine about it later. So
right now, what is the so a lawyer our legal team still has to remain advisable to her. Yes, she doesn't just get to do this all by herself. There has to be somebody that is there to in some way advise her. Yes, or that she can turn to, or does she just go on her own? Like, how does this work?
Sure, that's entirely up to her, and to some degree up to her attorneys. But when I worked as advisory counsel, my position was that it's their case. They've decided to take it over. I'm a resource. And that's kind of the way it's looked at least I looked at it that way and under Arizona law, because you don't want to be seen as interfering with their right to self-representation.
Right.
So for example, if somebody calls up or the person calls up and said, I want to do X, Y, and Z, I want to file this motion. I say, no, don't do that. Don't do that. And they don't, and they come back, I've interfered with their right to represent themselves. So basically, I'm like I guess the best way to put it, the easiest way to understand it would be, I'm like a law library. You call me, you got a question, I'll give you the answer, but my job is not to strategize with you to help facilitate whatever crap you're trying to pull or whatever it is. Again, there's that important legal term, crap.
Right, crap. Yep.
Like
very high technical legal term. Yes.
But so whatever they're up to, you just stand back and you are a resource to them. So you're not interfering with their right to counsel as well.
So in other words, if she has questions on, say she wants to question a certain witness and she asks her advisors, and they can say, you can do this and this and this, but not this and this and this, is kind of the only thing, right, that they're doing.
Yeah, I mean, that typically happens like in a courtroom. Say maybe they ask a leading question, somebody objects, they don't know how to do it, and then they come back and they check with their advisory counsel, and then they say, well, you need to phrase it differently like that, right?
Okay.
Before trial, it might be a, how do I file this, or what do I cite for this?
To suppress some evidence or something.
Yeah,
like
something
that,
like
right?
that. Yeah, they might come up and say, or I want this piece of evidence because the jail's going to limit how much they have. I want to look at this piece of evidence. So that's what the advisory counsel does.
I see. So now, when she's dealing with the witnesses, so like, because Brandy and I talked about this, and we feel like this is maybe a big FU to Landon and Al, and a way to kind of torture them. Because she's just all about that. That's just what she's like. She's just a very person that likes to torture people and cause damage. And so is she going to be able to have access to them and questioning them? Are they going to have to, allow her to do that? Or will someone else step in on that, since she is basically accused of killing their child?
Right. That is the big question, and that comes to a lot of people's mind and concern. And that ultimately is going to depend on the judge.